Yeah, so chal, that's great. Okay, so I'm really sorry that I had to kind of schedule the class on a holiday, but it is essential to do so because I have to start damages for both the sections by Monday. And if I would not have taken this class, it would not have been possible for me to take a joint class on Monday, and then we would have to reschedule that class. And again, similar kind of difficulties. I just thought that in today's session we have like I mean it's a scheduled slot on Thursday, though it's a holiday, but most of us have lost the tracks of university holidays anyways. We are like locked down at home, so I just thought that it's the best way to kind of take the class today and on like and make you reach the stage where my section presently is, so that we can then easily go ahead for another 8 9 lectures that we are left with in this course and discuss the law of damages on that front in a combined fashion. I don't know if Ruchika is attending the class or not, but even if she's not around, please inform her that Monday we have a combined slot, but on Thursdays you people have it here. In my section it's some other class. If we can have some other 2 hour slot where I can address both the sections in a combined fashion, and we can have like say on Wednesday, on Thursday, say Thursday 4 to 6 or Wednesday 4 to 6 anyways, which is kind of fine with you, or any other time which kind of suits both the sections and I can have the classes in those slots. I would prefer doing that because it's a common thing that I want to teach you, and I want all both the sections to be on the same pedestal when it comes to these areas because they're slightly tricky. I don't want anyone to miss on any kind of discussion or any question which is being asked. So that is the idea of addressing all of you together. Anyways, in none of the classes students attend for more than 25 30 minutes, or for more than 25 or 30 students they don't attend the class. So even if I combine both the sections, it will be a strength of 60, which generally is the strength of the section. So uh, I mean, I think that's fine. So both the CAD representatives, Aditi as well as Ruchika, should sit back and kind of decide on a slot in which we can, like Monday 9 to 11, we're definitely having. Any other slot that we can have for both the classes, for both the sections in which I can kind of cover the course. I would request you people to kind of locate a slot and please let me know. Fine. So I think in the last class that you had with Rajesh sir, he was discussing with you people on the idea of frustration, that what is it that we mean by frustration, what is it that is the basic understanding of the concept per se, and what do we mean by commercial hardship, frustration, what are the heads of frustration. I hope you people have kind of done it to that extent. Have you people did he discuss the heads of frustration with you? Yes or no? Yes or no, guys? Just type Y or N. . No. Did you not discuss the destruction of subject matter, change in circumstances, intervention of legislations and administrative authorities? All these things you people did not discuss on frustration? Yeah, so he discussed commercial hardship with you people. Did he discuss the cases Satyaprata Ghosh versus Muniram Bangar, Alopi Prasad, and other cases on that particular front? Maybe not under the Taylor versus Cladwell, Robinson versus Stevenson. Don't get stuck on the heads, guys. I'm just telling you the cases. Did he do those cases with you? Because what he told me was that I need to begin from section 65, the effect of frustration, which means that he has kind of. So fine, I'm believing that you had a discussion on commercial hardship and on frustration. He would have discussed the major cases with you people. Fine, that's fine. I mean, it's not that the case, if you have done some of those cases, that's fine. It's not that the case list has to match for both the sections. The major idea is that you should know and understand the concept of frustration per se. And if you know that, I hope that it's that's fine. We can kind of move ahead. Yes. So one important. So I'll take up from where he kind of left the session. One of the major ideas in frustration is that frustration is a doctrine of supervening impossibility, which basically, and both these things are very important. It should be an impossibility which is supervening, right? And the entire doctrine of commercial hardship revolves around this particular idea that even if it is impracticable, even if it is non-profitable, you should still go ahead and work around with that particular thing because it is still possible. For if it is impossible, then it's a different thing altogether. But because it is possible now, right? It is something which can be, which we can be kind of doing or performing in terms of our obligations. Even if it is non-profitable, even if it is impracticable, we will still go ahead and perform that particular thing, right? Like if you look at the case of Satyaprata Ghosh versus Muniram Bangar, right? So the argument was that because the land was taken by the troops in the Second World War, we could not develop the land and hence the agreement got frustrated. But the court said that once the Second World War has ceased to exist and the troops have kind of retreated from that particular area, why is it that you can't develop it now? Develop it now. You were not able to develop it a decade back, develop it a decade afterwards. Maybe the entire scheme of things will change. Maybe the scheme of market will change post World War II. Maybe you'll suffer some commercial hardships, but that's not something that you're concerned with. You're concerned with, can you perform the agreement? If the answer to that is in positive, you need to perform it, right? So that is the idea of impossibility, right? That the commercial hardship or any kind of impracticability or any kind of apprehension of non-profitability will not work. On the other hand, we have the idea of a supervening impossibility, right? So this term supervening is also very important when it comes to frustration, and which essentially means that it should not be something which is very much in the control of the parties. If the parties have a control over something and thereby the performance becomes impossible, or if the performance becomes impossible because of an act of a party, we do not say that the frustration doctrine can be invoked at all. The frustration can only and only be invoked when the impossibility in question is supervening, right? And one of the cases on this particular front is the case of National Maritime Fish Company versus ocean trawlers. I've sent the name of the case in the text. National Maritime Fish Company versus ocean trawlers, right? So now in this particular case, a particular trawler was hired by a person, and the name of that trawler was Saint Cuthbert, right? And that particular trawler was to be used to catch fish in the Canadian waters. And it was an understanding between the parties and the law of Canada that for fishing in the Canadian waters, you essentially need a license from the government of Canada. Now, this hire of the trawler, he had 5 trawlers at his disposal that he had hired, and he applied for 5 licenses with the government of Canada. The government of Canada but granted him only three licenses and said that you can operate only 3 trawlers in the Canadian market and in the Canadian waters and no more. Now this man chose 3 trawlers out of those 5 that he had, but did not choose the trawler in question, which is Saint Cuthbert, and returned the trawler and asked the owner of the trawler that you take the trawler back to yourself because I could not get the license. I am not able to perform my part of the agreement. The trawler owner said that, look, I want the money, the higher money for this trawler. And the hirer said, look, I cannot, the agreement has got frustrated because of governmental interventions. I had believed that I'll be paid a certain amount by the, I had believed that I'll be granted the license to operate this trawler, but I was not granted the license. And the matter went to the court of law, and the court was to decide that returning of the trawler and not paying the higher amount, was it a breach on the part of the hirer or was there a frustration in that particular case? The court in this case came to a conclusion that it was a breach and not frustration. And why did the court say so? The court said that the owner of the trawler, or the hirer of the trawler, had 5 trawlers at his disposal and he had 3 licenses. Now, which trawler does he choose to operate on those licenses was very much in the hand of the hirer himself. It was his choice that he chose not to choose Saint Cuthbert or the trawler in question, right? And therefore, the impossibility in this particular case is not a supervening. Rather, is an impossibility which has been induced by the party himself. The party could have easily chosen that particular trawler over any other one, right? And thereby could have respected the contract. But the party chose not to choose that trawler for any reason that is best known to them, right? But that impossibility is induced by the party itself, and therefore we cannot call it frustration, or the frustration is something that deals with supervening impossibility, or an impossibility which is not in the control of the parties, or circumstances are not in the control of the parties. If the parties themselves induce, in that particular case, we cannot call it frustration, right? Similarly, the another idea on frustration is that frustration has to operate automatically. It's not, I mean, that's an idea which emanates from this, is that frustration operates automatically. It is not something which is very much in control of the parties. It is not something which the parties can work around. It is also not something which the parties can establish due to any of their acts. These are surrounding and supervening circumstances in which the parties get placed against their will, or at least against their own, against their own actions, or devoid of their own actions. The parties get placed in those circumstances and then say, okay, fine, we are not able to perform the agreement for these circumstances exist around us, right? So frustration operates automatically. It's an idea of law. The courts need to decide whether the agreement has been frustrated or not, or whether the parties have got placed in such a situation that that we should be calling it frustration or not. It's not largely a question of fact, or I would rather say it's a mixed question of fact and law, right? Wherein the courts will look at the circumstances, which are the facts, and then we'll apply the law that whether it's really frustration or mere commercial hardship, is there any possibility, bleakest of the possibilities of performance of this particular contract or not? And that's exactly where the idea of law comes into being, that the courts really don't want to appreciate the plea of frustration quite much. And the courts are of the opinion that we should be restricting the plea and have restricted contours for the plea of frustration to the extent possible, right? So that is the idea of how frustration operates. Now, another important understanding and another important idea in the law of frustration is that how do you see the effect of frustration? That what would be the effect? Suppose an agreement has been frustrated, or the parties have said that, look, we are placed in a situation of supervening circumstances wherein the agreement cannot be performed owing to impossibilities. What in that case would be the result of it? The parties are now discharged. What will be the result of it? And that is a question that we need to ask. So Mahadri asks the question and says that, so if a singer has a contract to sing a week down the line and a week before takes some drinks and falls ill and is unable to perform, is this supervening? No, this is not supervening. See, if he does something which he knows will make him, say for example, I am allergic to a particular kind of drink, say vodka. I'm allergic to vodka, say for example. And I have to sing at a particular place, and a few days before that, I consume vodka. because of which I fall ill and I'm not in a position of kind of singing. In this case, the illness, I could have prevented it by being more careful and not consuming things to which I'm allergic to, right? So in this particular case, or in such a situation, if the impossibility comes up, that is not a supervening impossibility. That is rather an impossibility which is self-induced, or at least could have been prevented by due care and caution on the part of one of the parties, right? So there is an idea of taking due care of the subject matter of the contract, or something which is fundamental to the contract. And if you don't take due care, and that thing which forms the heart of the contract gets distorted in a fashion so as to render the performance impossible, you cannot claim frustration then, right? So another question will say that if there is a bleak possibility of performance, however, it shall be very unreasonable for one to perform, will it still be breach? Yeah, it will still be breach. We are not getting into the question of whether it's reasonable or not. If you can have if you have a very specific example of that particular thing, maybe we can still discuss that. But otherwise, as the law stands, it's not about practicality of performance, it's rather about the possibility of it. If it is possible, we'll make it perform. Abhinand says that is the standard of supervening impossibility a universal standard for the doctrine of frustration? Yeah, that's a universal standard. The doctrine of frustration means a supervening impossibility coming up and hindering the performance of a contract. What if you are not allergic and still fall ill? Let's say you just drink some soft drink. Yeah, so see, try to understand it this way. If I'm aware of the fact that a consumption of a particular thing will make me fall ill, and I still do that, it's that. If I am not aware of that particular fact, and despite taking all due care and caution, and despite thinking on all the fronts, I consume it and then fall ill, in that particular case, it's none of my fault. Then fine, even if I then fall ill, that's fine. Say, for example, I consume food, right? And the food being old, which I had no idea of, I encountered food poisoning. Now, in that particular case, there is frustration in that situation, right? Because, right? So, therefore, in such cases, you are really posed with the questions which are factual in nature. That's what I'm saying. It's a mixed question of fact and law. The facts need to come up and say, okay, fine, this is the fact and this is how it works. And on the other hand, you have the law, which says that, okay, we'll look at, even if there is a bleakest possibilities of performance, and then we'll make it perform if it is so possible, right? For example, if Corona happens and now the singer can still go ahead and sing, but it is very unreasonable, will it be breach? See, try to understand that Corona happens, and in that particular situation, he kind of does away with his contract to say that there is a possibility of me coming up with encountering some kind of illness in a large public gathering, right? Or the government says that there is a lockdown. In that particular case, it shall operate as frustration per se, right? But if, right, so in that case, you will say that it will be frustration for you. Are not just talking about commercial hardship, you're rather talking about the governmental orders. You're also talking about in terms of the safety of the person, the other things that he needs to kind of take into consideration. It is a supervening circumstance that has happened, which is preventing now a gathering or other things of that particular sort, and hence we can very well call it frustration. Fine. Right. So now the another idea is, what is the effect of frustration per se, right? So frustration, just like voidable agreements, when you say what is the effect of agreement being what is the effect of an agreement being voidable? You say that if the agreement is voidable, I taught it to you in the first class that I had with you on the exchange basis, that the idea is of restitution, that you restitute the parties into the original position and say, okay, fine, if you have been induced into the contract by undue influence, or if you have been induced into a contract by way of fraud, right? So whatever benefits have flown from one of the party to the other under that particular agreement, right? Such things will be restituted, right? Such things will be restituted, and therefore, in such cases, the agreements will be declared to be void, because they are voidable at the option of one of the parties. One party exercises that option, declares it to be void, and the parties restitute themselves into the original positions, right? So that is one of the ideas. Similarly, in cases of frustration or in cases of where the agreement is void ab initio or is declared to be void at a later stage because of operation of law, right? The idea of the effect of that lies under section 65 of the Act, right? Section 65 of the Contract Act. Please open that up on your respective laptops, guys. Section 65 Contracts Act. Right? I assume that all of you have opened that section up. It says that when an agreement is discovered to be void or when a contract becomes void, any person who has received any advantage under such agreement or contract is bound to restore it or to make compensation for it to the person from whom he received it. Right? That is the basic idea in here, that when an agreement becomes void or is discovered to be void at a later stage, right? In such cases, any person who has received any benefit from the other party under that particular agreement is required to restore that benefit to the person from whom he has so received the benefit. Again, an idea of restitution similar to that of section 64. It's just that section 64 talks about effects of voidable agreements. Section 65 talks about effects of void agreements, right? So that is the basic idea of frustration. That is the basic idea of the effect of frustration, right? That the parties need to restitute the benefits that they have received from each other under the contract. Now, this particular phrase, under the contract, is a very, very important phrase, right? Is a very, very important phrase. And we need to understand it in a case on that particular point, which is a bit peculiar, typical, but still very interesting, is the case of Jagdish Prasad Pannalal, Jagdish Prasad Pannalal versus Produce Exchange Corporation of India. Jagdish Prasad Pannalal versus Produce Exchange Corporation of India. Now, in this case, a particular agreement was entered into between a buyer and a seller for sale of a particular commodity, right? And the control price for that commodity, or the ceiling price which the government had set for that particular commodity, was 78 rupees per ton. The agreement was entered into at a rate of 77 rupees per ton, right? And the parties had decided that we will be performing the contract. The government subsequently changed their notification or brought a change to their earlier notification and said that the control price for the commodity in question is now 48 rupees per ton and not 78 as it earlier was. As a result of which, the sale price in the contract exceeded the control price by a huge quantum, because the control price is now 78 rupees per ton, 48 rupees per ton, and the price and the selling price in the contract is 77 rupees per ton, right? So now the parties were unaware of this notification and they kind of traded with each other, right? They traded with each other, and the seller of the commodity sold the commodity and the purchaser paid at a cost of 77 rupees per ton. The question which was kind of, afterwards the purchaser got to know that the price had got reduced, and he went to the court of law and said that I want the remaining amount of, or the balance amount, which is the difference between 77 rupees per ton and 48 rupees per ton, which is now the new control price. And the question before the court was that should the court restitute the benefit in here or not? Though this is not a case of frustration, but this is a case of a contract which gets rendered void on account of the fact that it is in violation of a particular law, and therefore the consideration in here being in violation, the agreement is void under section 23 of the Act. So the court in this particular case said that section 65 will not get applied. So see, section 65 is not something which gets applied only in the case of frustration. It gets applied in case of any void agreement, any agreement which is void from its inception or gets declared void because of frustration. It gets applied to that, right? So now the court in this particular case said that the agreement had become void on the date when the notification was passed and the notification came into effect. On the date when the notification came into effect, the agreement became void. Now it was after that the agreement has become void that the amount of that you had kind of done the sale and purchase of the things. And therefore, whatever sale and purchase has happened in this particular case has not happened because of has not happened because of has not happened under the agreement. And because Section 65 requires restitution of those benefits which have granted by one party to another under the agreement, we cannot do that over here because nothing has been transferred from one party to another under the agreement. Because what has been transferred is only after when the agreement has become void and is no more enforceable in the eyes of law. And therefore, now we cannot restitute the benefits because the benefits have not been granted as a performance under the agreement, for the agreement was void at the time when it was performed owing to the governmental notification of reduction in the control price. Right? So this particular phrase which says that under the agreement, which is flown, benefits which have flown from one party to another party under the agreement, is a very, very interesting and an important phrase in here as far as Section 65 of the Act is concerned. Right? Now there are another two important phrases in here, which are the phrase of an agreement which is discovered to be void and an agreement which becomes void. Right? Now if you look at Section 56 of the Act, frustration, it talks of two kinds of impossibilities. An initial impossibility and a subsequent impossibility. An agreement with an initial impossibility is void ab initio. It is created void. To say that I will find you a treasure by way of magic, if I enter into that kind of an agreement, it is created as a void agreement for the parties at the time of its very creation know that it's impossible to perform. So it's an initial impossibility which the parties are aware of at the date of creation of the agreement. Right? On the other hand, there is a subsequent impossibility, right, wherein the agreement becomes void at a later stage, right? So that's where these two kind of phrases come in, where an agreement is discovered to be void or becomes void, right? So discovered to be void is an agreement which is void from its very creation, but parties for some reason, which is legitimate, or parties for some reason don't really know that the agreement is void, and they innocently believe in the agreement to be valid, and they cannot be presumed to have any notice of that particular fact, which makes the agreement to be void, like an existing law or something of that sort, right? So therefore, in such cases and in such situations, the agreement becomes void at a later stage because the parties get to know of its true nature afterwards, and that it cannot be performed, or frustration or anything of that particular sort. Right? It becomes void at a later stage for the parties who are not aware of it being void at a it is discovered to be void at a later stage for the parties who are not aware at the time of its very creation that it is void. Right? One of the examples of it could be government contracts. So say there are certain technicalities, certain procedures which the government needs to follow, and which the government employees have a notice of, that in order to enter into a contract with a private party, we need to follow these procedures. Some of those procedures are not followed by the government, and an agreement has been entered into, and third party very innocently believes that yes, the agreement has been entered into by us and we are kind of very well performing it. Afterward, when a dispute arises, the government says that some of the essential procedures were not followed, and because of those procedures not being followed, the agreement here is the agreement here is void. Now, this is an example where the agreement will become void because the governmental formalities have not been followed, right? And the procedural formalities, say under Article 229 of the Constitution, which talks about government contracts, have not been followed, right? But the other party was not aware of it, and hence the agreement is discovered to be void at a later stage by the parties, right? And therefore, in such situations, right, the court will say that okay, restitute the benefit because it is discovered to be late. Parties were not at fault that the agreement is void. They did not knowingly make a void agreement or enter into a void agreement. They just unknowingly and innocently entered into this kind of an agreement, right? And hence the agreement is void, and the restitution should happen. But there are certain cases wherein the parties are culpable, or parties knew that we should not be doing a certain thing, but they still do it, right? And in that particular case, the court doesn't interfere, and for that we have a doctrine known as the doctrine of pari delicto. Doctrine of pari delicto. PARIDELICTO. I've sent it on the chat. The doctrine of pari delicto. This doctrine basically says that if an agreement is discovered to be void at a later stage, and it is found that the agreement is void for an illegality of it, on which both the parties are equally culpable, and both the parties knew that they are doing an illegal act, in that particular case, the court shall not grant a benefit of section 65 to them and will not restitute any benefit. For if the court restitutes the benefit in that, this is the most important idea. For if the court restitutes the benefit in that particular case or interferes or at all entertains that particular kind of a dispute, the court is legitimizing that agreement which the culpable parties have entered into. The court is essentially legitimizing that kind of an agreement which the culpable parties have entered into, and therefore in such cases the court shall not entertain an agreement, and the inspiration for it comes from the very definition of the word contract in the Indian Contract Act, which is an agreement enforceable by law is a contract. And they're saying if both the parties are equally culpable and they have done something which is wrong or they have done something which is illegal in nature, that agreement does not qualify to be a contract. And if that agreement does not qualify to be a contract, it is not enforceable. And the entire meaning of enforceability is to redress your grievances in the court of law pertaining to that particular instrument. And if we then take your grievances and then kind of start addressing them, then we are essentially making the contract to be enforceable. And it's exactly from where the inspiration for pari delicto comes in from, right? That the pari delicto is an idea that if the parties are equally culpable or if the parties are equally wrong in entering into a particular kind of an agreement, or they knew that they are doing something which is not correct or which is not permissible in the law, or which will make the object or the consideration of the agreement unlawful as per section 23 of the Act, in that particular case, the court will essentially not entertain that kind of a thing, right? Will not entertain that kind of a thing and will say, okay, fine, you please manage your own affairs by yourself, for the agreement that you have entered into is not an enforceable one, and we really don't want to intrude into that, for it is an unenforceable and the courts need to keep them outside their business, right? But then there are two exceptions to this doctrine of pari delicto, which is firstly where one party who is seeking a relief or the plaintiff is lesser culpable, or there is a reason to believe that that particular person might not really have known that what he is entering into is in derogation of law or is unlawful, right? If that is the case, then the court will allow for restitution. Similarly, if the case is that the illegal part of the agreement has not yet been performed, to take an example, say a particular person enters into an agreement to marry her daughter, a minor, to another person's son who is also a minor. Both bride and groom are minor and they are entering into an agreement for child marriage. And say there is some money which flows from the side of the bride to the groom's side, and before the marriage gets solemnized, the father of the bride says, I want the money back, or I don't want to marry my daughter to you. In that particular case, the court can still allow restitution, for the illegal part of the agreement has not yet been performed. Though they had agreed to do that, but has not yet been performed, the court will see it as prevention of a illegal act, and thereby will intrude and say, okay, fine, let's kind of do it. So if the illegal aspect of the agreement has not yet been performed, and the agreement is void for a reason of its illegality, but the illegal part has not yet been performed, the court may still intrude and say that, okay, fine, the agreement is an illegal one, just restitute, and just to prohibit its enforcement or just to prohibit its performance at a later stage, right? So these are two exceptions to the doctrine of pari delicto. Now we have another phrase under this which says becomes void. So if an agreement becomes void at a later stage, whatever advantages have flowed from one party to another under the agreement, right, they will be restituted. That's quite clear. But the English position on that particular front was not that earlier. But if you look at Krell versus Henry case, have you read Krell versus Henry case, guys, the coronation case? Yes or no? Has Krell versus Henry been discussed in your class? Yeah, good. So if you look at the Krell versus Henry case, the court in that particular case said that neither is it that the parties are required to the case was this, that some balconies were taken on hire, some flats were taken on hire to see the coronation proceeding. Advance amount was paid to the balcony owners, and a remaining amount was yet to be paid. When the court declared the agreement to be void, right? When the court declared the agreement to be void, advance amount to the flat owners, the flat owners are not required to give that amount back to the parties, right? So they said that the flat owners are not required to give that amount back to the parties, and also the hiring parties are not required to pay any further amount. So they said whatever is the status, whatever amount the flat owners have got, it will be with them. Whatever amount the hirers have not paid, it will be with them. So the code did not allow restitution or transfer of benefit. Otherwise, the code would have said that whatever amount the flat owners have got, they need to give it back to the hirers, but the code did not do that. The code said maintain the status quo. So English position was not same as section 65 earlier. But in 1943, with a case in the name of Fibrosa-Spolka versus Fairbairn, right? Fibrosa, Fibrosa-Spolka versus Fairbairn. It's a 1943 decision, right, of House of Lords. Fibrosa-Spolka versus Fairbairn. 1943 House of Lords. So in this particular case, the court said, the facts I'm just discussing very briefly. There was a machinery which was to be installed at a particular place, and some amount was paid against that installment of machinery and purchase of it. And a war broke out because of which the machinery could not be installed, and the frustration and the plea of frustration was taken. The court allowed the plea of frustration and said that the law in Prell versus Henry is not good, because it goes against restitution. Once the agreement has been declared to be void, the party should be restored to their original position, as the agreement would never have been created. And therefore, the court said that the agreement should be of this sort, the effect should be of this sort of frustration, that the effect of frustration should be of the sort that the machinery should go back to the owner of the machinery, and the money which the owner of machinery has received from the purchaser should be given back to the purchaser himself, and the party should be restored into a position as if contract would never have existed in the first place, right? And thereafter, within a year of, not even a year of this particular decision by the court, the England Parliament came up with an act called as the Law Reform Frustrated Contracts Act of 1943, under which they created an agreement, they created a provision for restitution in the case of frustration, which is very much synonymous to our section 65 of the act, right? So with this, we are done with frustration as a head. Anyone who has any difficulties or any doubts in whatever I have discussed as of now, please feel free to ask, guys, if you have any difficulties, any issues, any concerns with whether I have discussed the cases and stuff. No questions, nothing? Great. So now we move on to another head, which I intend to cover in today's class, and that is the head of discharge by agreement. So if we look at the Contract Act per se, we can divide the law, the general principles of contract, into two major parts. First is the part of creation of contracts, and the other is the part of discharge of contracts, right? Formation and discharge, or creation or discharge. These are the two major parts under which we can divide the Contract Act. So from section 30 of the Act until section 30 of the Act, it concerns itself with the formation of the contract. If you look at section 10 of the Act, which says what agreements are contracts, say an agreement is a contract when it is made by free consent of parties competent to contract for a lawful object with a lawful consideration and not explicitly declared to be void hereby, right? These are the 5 essentials of a valid contract, of a contract. So, and the agreements which fulfill these qualifications are called the contracts, right? So, if you locate the subsequent sections from section 11 to section 30 of the Act, they are just elaborating on these 5 essentials. That what do we mean by free consent? What do we mean by competence? What do we mean by lawful object? What do we mean by lawful consideration? And what are the agreements which are explicitly declared to be void in here? They just talk about that, right? So that is the stage of creation of the contract. The moment you locate it from section 31 to section 75 of the Act, right? That is what we call as the clauses, or sorry, the sections concerning the discharge of the contract. So discharge, again, we have 4 modes of discharge. First is a discharge by performance, right? Second is discharge by operation of law, which is basically frustration. Thirdly, it's discharge by agreement of the parties, where the parties agree to discharge each other from the obligations. And fourthly, it is discharge by breach, right? So there are four modes of discharge. Discharge basically means the ways in which the parties can do away with their obligations under a particular contract, right? The ways in which a party can do away with their obligation under a contract, or in which their obligation may cease to exist, or the agreement ceases to bind them any further. That is basically the meaning of discharge. At what circumstances should happen for, or what should happen to conclude that the agreement ceases to bind the parties anymore, right? That is the idea of discharge of a contract, right? So one way is to perform the contract. You perform the contract and you get discharge of your obligation. Once the performance is complete, the agreement will no more bind you. Second is by operation of law or frustration, which is to say that once there is supervening impossibility, the parties will get discharged and there will be no performance in there. Thirdly, it is discharge by way of agreements, wherein the parties agree to each other or amongst each other to say that we are agreeing on a particular thing in a particular fashion for limiting the obligation under the contract, or for doing away with the pre-existing obligation under the old promise and now coming up with the new promise. I'll discuss that in detail now. And then we have discharge by breach, that one party breaches its obligations or breaches the contract, and his breach not only discharges himself from any further obligation, but also does discharge the other party from any obligations under the contract, right? And thereafter, the party who has suffered the breach can file a case of damages and seek for that. Breach is something that I'll deal at a later stage in today's class. For now, let us come up and discuss around discharge by way of agreements, right? Now, what is it that we mean by discharge by agreements? That in certain cases, the parties may decide, right? In certain cases, the parties may decide to limit their obligations, right? To limit their obligations or to change the nature of their obligations by way of an subsequent agreement to do so. So I enter into an agreement with you to say that you have to deliver me 100 bales of cotton at a certain price, say X. Now at a subsequent date, we enter into a subsequent agreement referring to this agreement, and I say that let us change the price for 100 bales, and I say that let us change the price for 100 bales of cotton to Y. And you agree to that. Okay, fine. We may change the price of that much quantum of cotton to Y, and the price is now changed. In this particular case, or in this particular circumstance, we have discharged each other from the earlier obligation to pay or receive X price, right? And the parties get discharged from that particular obligation to pay or receive, obligation or right, whatsoever it is, to pay or receive X price. Or suppose we enter into an agreement and say that, okay, you know, no more need to I say 100 bales of cotton at 1,000 rupees. I now say that you no more need to deliver me 100 bales of cotton, just deliver me 90 bales of cotton at 900 rupees. Now in this particular case, both of us get discharged to some extent from our pre-existing obligation, right? Or from the obligation under the earlier contract. I need to deliver 10 bales less and you need to pay 100 pounds less, right? Or sorry, 100 rupees less, right? So that is the basic idea of discharge by way of agreement, wherein the parties agree to change the obligations as they existed in the earlier contract. It is not always that the discharge would mean reducing the obligation. Sometimes discharge would mean reducing the obligation. Sometimes discharge may even increase the obligations. But the idea here is that there is a pre-existing contract. The parties enter into a new contract referring to the earlier contract and change their obligation in the earlier contract, and thereby get discharged from the previous obligations and now assume new obligations. That is the idea. Now, new obligations would be higher than the earlier obligations. There's no rule saying that the new obligations can always need to be lesser than the earlier obligations. There is no rule of that sort. But the idea of discharge comes from the fact that the parties get discharged, or the parties get relieved from the obligation under the earlier contract and now have to follow the obligation under the new contract, and hence the old contract's performance gets discharged. That is the idea of discharge. Not essentially remitting or the obligation. Remission is an aspect of discharge, but not the only aspect. You can even increase the obligations, but that increase in obligation essentially discharges the party from the earlier obligation. That is the idea of discharge in here. So please don't confuse it with reducing the obligation per se, right? So there are several modes in which an agreement can get discharged. And the three major modes of discharge by way of agreement are novation, remission, and alteration. Novation, remission, and alteration. Novation, remission, and alteration. Right? So we'll discuss it one by one. Section 62 of the Act talks about the effect of novation, rescission, and alteration of a contract. Now, rescission is another aspect. Rescission, I'll discuss it with you. What is rescission? Right? Rescission, I had discussed it with you earlier when I was discussing the aspect of under section 19, that what we mean by receding back from the contract. But rescission basically is to step back. So if I am novating, if I am changing the obligation of the earlier from the earlier contract, right, or if I'm changing the terms of the earlier contract and substituting it with new terms, I am essentially receding back from the old contract and assuming new obligations. That is what the idea of rescission is. And rescission can happen by any of these three ways: novation, remission, and alteration. The moment you recede, right, by way of novation, remission, or alteration, you also discharge yourself from certain obligations, right? So let us read section 62 of the Act, which is effect of novation, rescission, and alteration of the contract. Please guys open it up. So it says, if the parties to a contract agree to substitute a new contract for it, or rescind or alter it, the original contract need not be performed, right? The original contract need not be performed, right? So when you novate or you alter the contract, you recede from the earlier obligations. You may also choose to recede from the existing contract and say, okay, we don't want to perform this contract anymore. Let this contract come to an end. You don't substitute it with anything new. There are no new terms. There are no new contracts coming in. Just say we are receding back from this contract. We don't want to perform it anymore. You enter into an agreement and the contract comes to an end. You may do that as well, right? That is also kind of rescission, wherein you just recede from the contract and say, okay, fine, we are stepping back from the contract, not assuming any new obligations. Let the obligations go to hell. We're not doing anything. Right? Let us discuss them one by one. First, let's come to novation. So novation is an idea when the parties change the earlier contract or the earlier promise that exists between them so drastically that the change that comes in gives altogether a new contract. The change which comes in, it gives altogether a new contract, right? And not something which is at all than as what was discussed earlier. Right? So there can be two ways of novating an agreement. First is change the parties. If I enter into an agreement with you and subsequently you say, okay, I want to drop off from the agreement and let Mr. X come in my place. I say, okay, fine, let Mr. X come in your place. That's something which is fine with me. I just need the agreement to be performed. In this particular case, the agreement which was between me and you earlier is now between me and Mr. X. Right? Is now between me and Mr. X, right? And therefore, in such a situation or in such a circumstance, the agreement becomes I mean, the older agreement becomes redundant, and there are new set of obligations which are between me and Mr. X, and you get discharged from that particular contract, right? So such kind of cases, they come up in the situations wherein there is assignment of debt. So say, for example, I enter into an agreement with you. I lend you a certain amount of money, say 500 rupees, and I have to recover that money from you. There is an agreement that I'll pay you 500 rupees. You'll give that money back to me by a certain date. Now you tell me that, look, Mr. Malik, Mr. X is indebted to me for 500 rupees. I need to pay you 500 rupees. Mr. X needs to pay me 500 rupees. Let me drop from this entire arrangement and X will pay you 500 rupees. And I'm saying, okay, fine. That's fine with me, right? What I need is my 500 rupees back. Whether I get it from you or from X, it doesn't really matter. that is the arrangement you are preferring, let's go with that. So the earlier contract, which was between me and you, to enter into a contract, is now between me and X. And because we have changed a party, now this is a very small change, all the terms being the same, what we have changed is a party. There is just one thing in the contract which has changed, is that you are now replaced with X. But that change is so fundamental to a contract. For who is a party to a contract is such a fundamental and an important question that it hits exactly at the heart of the contract, right? And therefore, such a small change or such a small substitution of your name with that of Mr. X essentially has an effect of changing the entire scheme of things, or changing the entire character of the contract, and therefore we say that the agreement has now been novated, or we have replaced the old agreement with a new agreement now, for the parties have now changed. That is what novation is, wherein you replace the old agreement with a completely new agreement. And with a completely new agreement, we don't mean that you kind of plunder the entire old agreement as it existed then. It's just that you hit at those specific things in the contract, or hit at one of those specific things in the contract which form the heart of the contract, or which largely define the character of the contract. You people have read under the law of mistake, when I was teaching it to you, that there is a distinction between the character of a document and substance of a document. And contents of a document. There's a distinction between character of a document and contents of a document. You guys remember that distinction that I discussed with you? Yes or no? Please type Y or N, guys. While discussing mistake as to subject matter of a contract, say Y or N, please. Do you remember that distinction? The distinction of character and contents of a document? We discussed it while I was discussing law of mistake with you people. So character of a document is something which basically defines the most basic ideas of it, right? On the other hand, the content of it is something which is merely certain ancillary terms of performance or certain ancillary stipulations in the contract. That is what content of it is. But character is what forms the heart of the contract. I'll discuss that with you, and it will be clear to you in course of time. I'm making this distinction at the very outset. It will play out in another 15-20 minutes as we start discussing other modes of discharge, right? So another way of novation is substituting a new contract for that of an older one, right? Substituting a new contract for that of an older one, which basically means substituting those terms with new terms which form the heart and soul of the contract, or which form the character of the contract, right? So one of the examples of that particular, of substituting the new terms for the old terms, is the case of Nagendra Kumar versus Hindustan Salts. Nagendra Kumar Brijraj versus Hindustan Salts. Now in this case, Hindustan Salts came up with an advertisement saying that we are advertising vacancies for a certain post at a certain salary, right? And there are several people who had applied for that, including the plaintiff in this case. He also did apply for that post, and he was selected on that post against the terms of the advertisement. Now he is selected. He said that you will join us with the terms of advertisement, and there is an agreement of employment that exists on the terms of advertisement. The day he joined the service, he was given a new contract on a lesser pay scale than what was defined or than what was explained in the advertisement, right? And he accepted the lesser pay scale and joined the service. Afterwards, he disputed the lesser pay scale and filed a case against Hindustan Salts, saying that in their advertisement they had said something, but when they appointed me, they have now appointed me at a lesser pay scale, right? And the court in this particular case did not grant any relief to the plaintiff, saying that there was an earlier agreement number 1, between you and Hindustan Salts on the terms of advertisement. But on the day when you joined, there was a new agreement which was given by Hindustan Salts to you on a lesser pay scale, and you agreed to that particular thing, and that change, all the terms being the same, a change in the pay scale, right, novates the contract, because how much money will you get in an employment is something which forms the heart of it. That is the basic, that is the major consideration in the thing, that I will render certain services and you will pay me against that, right? How much will you pay to me is something which forms the heart of the contract in the employment contracts per se, right? And because there was a change of such material terms, the court said there is a novation in the contract, right? There is a novation in the contract, and that novation has discharged the earlier agreement. That novation has discharged the agreement which had been entered into between Hindustan Salts and the plaintiff as per the terms of the advertisement. Now the employment shall be governed by the new agreement, and any fact which disputes the new agreement in light of the old agreement, any case shall not be entertained. For that case is not something which is, I mean, which can legitimately be undertaken as a cause of action under the law of contracts, for the earlier contract has now ceased to exist for novation coming into place. Is this case clear to all of us, guys? Is the idea of novation and this case clear to us or not? Just type Y or N, please. Okay, fine. So the case is quite clear to all of us. The effect of novation is also clear to all of us. Now let us come to another case on novation itself, which is the case of Manohar Koyal versus Thakur Das Naskar. Manohur Koyal versus Thakur Das Naskar. Manohar Koyal versus Thakur Das Naskar. Now, in this particular case, this is a very interesting and a typical case again. There was a bond which was signed in favor of another person, and the amount of that bond was 1173 rupees, 1173 rupees. So a particular person had endorsed a bond of 1173 rupees in favor of another person. Bond basically means that on a future date, I will pay you this much of amount, right? The date on which the bond was to be performed, the amount was to be paid, lapsed, right? The date on which the amount was to be purchased, that date had lapsed, right? And on lapse of that particular date, the amount was, till the lapse, the amount was not paid. After that, the parties entered into an agreement saying that you pay me 700 rupees against that bond at once and 400 rupees at a later date, which makes it 1100 rupees. So 73 rupees, the endorsee of the bond of the person in whose favor the bond was signed had 4. He said, okay, I don't want those 73 rupees. Just pay me 700 rupees lump sum at once and 400 rupees at a later stage. The person who was to pay the amount did not even pay that much, right? Did not even pay that much. And as a result of which, a case was filed, and the person in whose favor the bond was signed, he said that, look, I entered into an agreement with him that he will pay me 1173 rupees at a date. Then we changed that particular agreement, right, and novated it, saying that he has to pay me 700 rupees at a date and 400 rupees at a later stage, and we novated the terms of the agreement to that extent. For I am taking less from him, and also I have also changed the mode of performance. He is not paying me lump sum anymore. He is now giving 1100 to me in installments, and there is a novation in here. The court did not buy this argument. The court said that there is no novation in this contract. And why the court said so, and the reasoning is very interesting. The court said that there is no novation because you have entered into this subsequent agreement that he has to pay you 700 rupees and then 400 rupees at a later stage, right? Owing at a stage when the contract had already been breached. Remember, this agreement of paying 700 and 400 rupees installment was entered into only and only after the due date of the bond had expired. The due date of bond of 1173 rupees had expired. It was only after that this particular amount was paid. That this particular agreement of receiving 700 and 400 rupees installment was entered into. So the court in this case said that there is no novation. If you would have entered into this contract before the date of maturity of the bond, then it would have been fine. But now, because you have entered into contract after the maturity of date, the contract had already been breached, which means that the agreement which you are saying has now been novated. On the date when you say you had novated it, it had already been discharged by way of breach. And therefore, there can be no novation in this particular case. And this is a case of breach, and the person needs to seek damages for breach of contract and not essentially performance of the novated contract per se. Right? That's what the court in this particular case said. Is this case clear to all of us, guys? Is this case clear or not? Fine. So we are done with an hour of the class. I think we should break now. I'm ending this particular stream. I'll send you a new link, right? And we shall begin with the class after 5 minutes. It's 5 minutes from now. It's 3:07 on my laptop clock. I'll begin sharp at 3:12 on my laptop clock, right? So fine, guys. I'm ending the stream for time being. We'll begin in the next stream. We'll continue with the other aspects of discharge by way of agreement and then discharge by way of breach. For now, I'm ending the stream, and I'll soon be sending you the new link. Thanks a lot.